I have the pleasure of introducing Kurt Erlenbach. He is a general magistrate for the 18th Judicial Circuit with the office in Titusville. He has been in this position for 10 years, preceded by 13 years as a child support hearing officer. He has been a presenter at the Judges Educational Conference every year since 2017, a teacher at the Florida Judicial College, which is a new judges school, and a presenter for the Bar CLE programs. He is the author of How to Write a Perfect Family Law Order, and formerly was the author of the Florida Criminal Law Notebook, and for 26 years, the Florida Criminal Law Weekly Report. He is a graduate of Cornell University, the Ohio State University College of Law, and a notary public. Please welcome Kurt Erlenbach.
Okay, good afternoon or good morning, folks. My name is Kurt Erlenbach. I'm a general magistrate for the 18th Judicial Circuit. That's Brevard and Seminole counties. I'm in Brevard in Titusville. I do family law and mental health for the 18th Circuit. And what I'm going to be talking with you about today are the changes that have gone on in family law as a result of the legislative session this year. This year was, for family law purposes, just an amazing session. The number of changes and significance of changes that the legislature passed this year have been unprecedented, at least in my experience as a lawyer and as a magistrate. There are four main laws that the legislature passed this year that have big impacts in the way we do family law. And I'm going to go over each of those, and we will discuss the main things that you need to know in advising your clients, helping your the lawyers with whom you work. And I need to point out there are some things that have changed this year that have rather significant misunderstandings, I think, in the import of the change, the significance, how judges are going to be looking at things. And one of the main things I want to do today is to help dispel some of the misunderstandings about the effects of these laws and how it should be looked at when the rubber meets the road, when a judge is being asked to decide on these various topics. So the first one that we're going to talk about is alimony. This is the big one. Alimony, this year the legislature made a wholesale reform in the way alimony works in Florida. Legislature has been trying for years to change alimony. It's a trend that's been going on in other states for quite some time. Florida has kind of now caught up. Alimony reform has passed a few times and been vetoed by a couple of different governors. But this year it passed, and this year we need to completely change the way we're thinking about alimony. Session Law 2003-315, this went into effect July 1st. Now, the import of that, back when I was young, laws in Florida mostly went into effect in October 1st. Legislatures changed that recently, and all these laws are going into effect July 1st. And this is particularly important. These laws affect not only new cases filed on or after July 1st, but also cases that are ongoing. Now, some of these alimony reforms really make a big difference in the way a case needs to be presented and the way the case is going to be decided. So the effect of changing these laws sometimes in the middle of the stream, while the case is going on, these can have some significant effects in how the case is going to be litigated. So keep in mind that all this stuff that we're going to be talking about applies now. All right. Used to be that a short-term marriage was 7 years or less, long, moderate term 7 to 14, and over 14 was long-term. Now 10 and 20 years. Under 10 is a short-term marriage, 10 to 20 is moderate term, over 20 is long-term. Permanent alimony is eliminated. Now, this is the one that's gotten, all the attention. No more permanent alimony. It's not as significant a change, and we'll be discussing exactly why in just a bit. But the kinds of alimony in Florida now are temporary alimony, bridge the gap alimony, rehabilitative alimony, and durational alimony. And one of the benefits of these changes is that you're now going to be able to give a client, if your client is the one who may be on the hook, potentially on the hook for paying alimony, you're going to be able to give them a better understanding of what they might be looking at, because unlike in the past where the court had no guides as to how long alimony could last and the amount of alimony, now there's going to be some guidelines as to how much, and I call them guidelines. They are essentially mandatory. The courts, under some circumstances, can exceed some of these limits, but as a general rule, these are mainly guidelines as to how much can be paid and for how long. So permanent alimony is gone. No more permanent alimony. Rehabilitative alimony cannot exceed 5 years. It can be ended if the rehabilitative plan has been completed. In my experience, lawyers are bad at doing rehabilitative alimony plans. They're somewhat difficult. How long will it take for this former teacher to be recertified and that sort of thing? But if the plan is to become recertified and get back up to speed to become a teacher again, figuring out just how long that's going to be is an essential part of a rehabilitative alimony plan. And the plan cannot exceed 5 years, and it can be terminated if the person is able to complete the plan before the time expires. Durational alimony cannot be awarded if the marriage lasts less than 3 years. And let me make sure you understand this. This is something that folks don't quite grasp as well as I think they should. The length of a marriage is the length of time from the wedding date to the filing date. It doesn't matter if the parties had lived together for 15 years ahead of time and then were married for 2.5 years before filing for divorce. That's a 2.5-year marriage. It doesn't matter. The 15 years before, it doesn't matter. It doesn't matter if they were married, they were together for 2.5 years, and then nobody filed for divorce for another 10. It boggles my mind to see how often that happens, where people separate and don't file. Not only does it mess up things like alimony and their alimony potential, but their Social Security gets messed up. There's all sorts of downsides to people being separated without divorcing. But the length of a marriage is wedding day to filing day, and that is essentially that's not negotiable. Now, those other factors can play into the amount of alimony, but the judge is going to start from the proposition that wedding to filing, those are the operative dates. Now, the reason that the changes in what's short-term, moderate term, and long-term, what really matters is that under the new statute, durational alimony cannot exceed 50% of the time of a short-term marriage, though it cannot be ordered if the marriage was 3 years or less, 50% of a short-term marriage, 60% of a moderate-term marriage, 75% of a long-term marriage. Now, the judge, this is one of those factors, one of those times when the judge can exceed those things for exceptional circumstance. But this is one of the main things that you all need to understand in assessing a client's exposure. Either exposure, how long they may be able to, how long they may be paying alimony, or how long they may be entitled to receive alimony. 50% of a short-term marriage, short-term marriage is 5 years, they can get 2.5 years of durational alimony. Now, other alimonies, a rehabilitative alimony plan can exceed 2.5 years. Bridge the gap alimony, temporary alimony, those things can exceed this. This is only applicable to durational alimony, essentially the kind of alimony that the judge may order in a final hearing, or it will be part of the final judgment. So a rehab plan can go longer. Bridge the gap can go longer if there's a good reason for it, and so forth. But these numbers are essentially, drop dead dates. 60% of a moderate term marriage. So if they're married, say 15 years, it's what, 7, 8, about 8.5 years is the maximum length that the court can order durational alimony. Now, getting rid of permanent alimony, which is obviously most applicable in a long-term marriage, this is where there's been a lot of hand-wringing over getting rid of permanent, and why I don't think that it is quite as big a deal as has been made out to be. Let's say you've got a long-term marriage, we'll say a 40-year marriage. Folks were, well, let's say 30. We got a 30-year marriage, or married at 25. It's now 30 years later, getting divorced at 55. The alimony can last 75% of a long-term marriage. 30 years, what's that, 15, 23, 22 and a half years. It can last 22 and a half years of a 30-year marriage. So for all practical purposes, for most circumstances, 75% of the length of a long-term marriage is going to be functionally the same as permanent. One of the other reforms that we'll get into in just a few minutes, one of the other reforms has been how to go about modifying alimony upon retirement. And so because of this 75% maximum really won't make a huge effect in most cases, just because of the age of the folks once they've hit that long-term marriage limit. So that's just one thing I want you to keep in mind in assessing or helping to calculate the maximum exposure for paying alimony or receiving alimony. These limits can be exceeded in exceptional circumstances with clear and convincing evidence. Now, the exceptional circumstances, of course, they're not set out in the statute, but I would expect them typically to be if a support recipient became disabled during the marriage, if the support recipient, for example, had given up alimony or other kinds of support to get married. You lose your SSI if you get married and you don't get it back. It takes a while to get it back frequently upon divorce. And so there could be exceptional circumstances, and I would expect mostly in circumstances of disability occurring during the time of the divorce or losing support, so long as it's established by clear and convincing evidence, and there are some new factors for the court to consider in figuring out how long it should be. So if you've got someone, for example, in a moderate term marriage, 10-year marriage, let's say 15-year marriage, married at 20, they're now 35, and became seriously disabled from working, for example, and their only source of income may become become durational alimony. There are bases the court can find to exceed the 60% length limit on a moderate term marriage or others. So just keep that in mind when you're doing these calculations. Now, the amount of alimony, and this is probably the biggest change for me as a magistrate who does alimony all the time. One of the more difficult things, and I know this from talking with other judges and magistrates, that this is something we all wrestle with, because how much the alimony should be is frequently a difficult thing to calculate. The duration, the amount of alimony, again, this is durational. Other kinds of alimony doesn't apply, but for durational alimony, the kind you'll get in that final judgment is the amount of the recipient's need. The lower level is the amount of their need, or an amount not to exceed 35% of the difference between the parties' net incomes. So that puts an upper limit on the amount that a party can be required to pay. 35% of the difference between the parties' net incomes. So to figure that out, you need to first figure out the net incomes. This is where you can use your child support calculator in calculating how much these parties' net incomes are. In fact, the new statute explicitly says that net income is to be calculated in the same way that net income is calculated for child support. So net income is gross income, wages or salaries plus overtime plus investment income plus money paid to reimburse expenses, all these things, everything that goes into income for child support purposes, minus taxes. And again, it's taxes adjusted to show actual filing status. If you're doing a divorce, keep in mind that they are going to be single after this calculation is made. So a single person with the correct number of exemptions, deductions for dependents, meaning you get people who, maybe they're paying for 3 or 4 kids, but they reduce the number of dependents so that they get a big refund at the end. Corrected, the dependents are corrected for the amount of, for their filing status. Minus their own health insurance cost, minus any mandatory retirement, not voluntary retirement payments, but mandatory ones, like we government employees that pay 3% to our pension, minus mandatory union dues. Union dues are almost never mandatory in Florida. And other things. So you can use your child support calculator, put in the parties' incomes, and get what their net income is. And I encourage you to do that. I do it all the time in figuring out alimony amounts, because now the statute explicitly says that it's calculated the same way as you calculate net income in child support. So once you calculate the net income of both parties, here's an example. If the husband's net is $10,000 a month, the wife's net is $5,000, alimony can't exceed $1,750. This is would be in a, well, $1,750, because again, the alimony would be the low end, the wife's need, the high end being this 35% of the difference of their incomes. So difference between 10,000 and 5,000 is $5,000. 35% of $5,000 is $1,750. So the range of that the alimony can be is $0 to $1,750 per month. This is a useful cap. It is a significant cap. There are circumstances where this limit may be seen as fairly low, but there is a limit. And so that when a client comes in and you're asked to figure out what their exposure is, now you've got a way of calculating it. Statute has for a long time included a provision about reducing or modifying alimony when the other party, when the support recipient is in a supportive relationship. Appellate courts had determined for a while that not only applied in modifications, but also in originals, and this new statute now makes it explicit that supportive relationship applies to both new cases, new alimony obligations, and modifications once a party enters into a supportive relationship. Now, exactly what is a supportive relationship, or when it applies, that's also been clarified, and it's clarified in good ways. This is a good change, this statute, in my opinion. There has to be a supportive relationship between the obligee and a person who is not related by consanguinity or affinity. We've had cases where, well, mom the former wife is now living with her 93-year-old mother, and her 93-year-old mother is supporting her. Well, it's clear that doesn't apply because they are related by consanguinity. Affinity is being related by, it's other non-blood relatives, like, an uncle or somebody who you're not related to by marriage, but related to by family. So you're not going to have a circumstance. It does apply if you're related to by, it's your boyfriend, but not if you're related to the person because they're your relative. That was never clear in the previous statute. So if somebody is looking to avoid or reduce their initial alimony obligation, the obligor, the person who is going to be paying, must prove, they have the burden of proof, proving it by a preponderance of evidence that there's been a supportive relationship, and the statute sets out what can be shown in a supportive relationship, but it must exist in the 365 days prior to filing a petition. So you get these cases, and I've seen a lot of them, where they filed to modify because the former wife's in a supportive relationship. By the time they come up for trial, the supportive relationship is done. All right, well, so long as it existed in the 365 days prior to filing, then the court still has the option of finding a supportive relationship for making a reduction. Okay, now there's also another good change in this statute. Sets out the rules for termination of support when the payor is looking to retire. Now, in the 1980s, I think it was, might have been the 90s, the Florida Supreme Court decided a case called PIM, it's P-I-M-M versus PIM. And that was the case that had always set out what the rules were going to be if a person wants to retire and wants to reduce their alimony obligation as a result. The first off is whether it's appropriate. When is it appropriate for a person to retire? Now, this new statute says may reduce or terminate the support when the obligor has reached the normal retirement age defined by Social Security Administration. Now that age is changing. So when you get a case in, you need to do a little research as to exactly what the normal retirement age is. I'll give you an example. I just turned 67. When I started looking for, looking at, what Social Security does for retirement, I learned that my normal retirement age was 66 years and 4 months. And that age is going up slowly. I think, I'm not exactly sure where the target age is, but it's going to be around 66 and a half years or so. Now, it also can be different if you have other kinds of jobs where normal retirement age may differ. Police officers or others that are in, people who may be in physically demanding jobs may have normal retirement age somewhat younger. But that's the main one, is the normal retirement age is defined by Social Security, or the ordinary age for a profession, for his or her profession. Some have requirements. Pilots, I don't know if they're still at 65. May have been increased. I'm really not sure, but some professions have mandatory retirement ages. That also, but they have to show that the obligor has taken demonstrable and measurable efforts or actions to retire, or is actually retired. If they've told their employer, I intend to retire on this date, that is a demonstrative and measurable effort to retire. One of the things that always came up in these PIM retirement reductions is, when do you file? When do you file for the reduction? Do you have to retire first? Should you file the month before you retire, or 2 or 5 months? I mean, how do you time the modification retirement? Remember, a modification can be retroactive to the date of filing. So typically, if you time it right, it should go into effect when retirement happens. Obviously, it makes a difference how long it may take to get to the point where a judge will decide whether you get a reduction because of retirement. So it may be a long time, maybe a short time, it may depend on the your circuit as to how long it's just taken to get there. So you need to show that they've taken a measurable effort to actually retire, or has actually retired before filing. And there's another provision, I think it may be in this slide, that says it can be up to 6 months before actually retiring. So once the petition is filed saying, I intend to retire, I want to reduce my alimony obligation, the burden is first, if the court determines that the retirement has reduced or will reduce the ability to pay, burden then shifts to the obligee, to the support recipient, to prove by a preponderance that the obligor's support should not be terminated or reduced. And the statute sets out factors for the judge to consider. So first, the support payer has to show that they are going to, they're going to reduce, it will reduce their ability to pay, and then the obligee can show it should not be terminated or reduced. So if you are assisting with representing the payor, the obligor, you need to be able to show what the current income is and what the income will be, taking into account, the 401k, the pension, the Social Security, all that stuff, what it's going to be after retirement. Court determines that retirement has reduced or will reduce the ability to pay. That's then when the burden shifts to the support recipient to show that their alimony should not be terminated or should not be reduced. And then it's up to the judge to figure out if it's reduced, how much, if it should be terminated, or what else should be done with it. Okay, so that those are the highlights of the alimony reform. It's important that you or the attorney that you're working with, you need to read this whole statute, the whole session law regarding alimony reform. It's there are other things in it that other little details that may apply in your case, and so I really suggest that you pull it out. The session law, it's session law 23-315. Get the session law and read it, because some of the details, I've not gone over all of the details, but there are things that can bite you. And I'm sure that the judge will appreciate that you or your attorney are aware of the new changes and the details of the changes. All right, now the other big change, or one of the other big changes, is in parenting. The other big change, part of this was in the alimony reform, but the other one is the Session Law 23-301, again, effective July 1. This one, I'll tell you, this drove a lot of us magistrates and judges kind of nuts, because the governor signed this bill on June 30th. It was kind of up in the air if it was going to be signed. We didn't have any reason to think it wasn't going to be signed, but it was signed the day before it became effective. And again, it's effective that day, and affected ongoing cases. So there was some scrambling going on to see how it changed things and how it affected things. But it's clear, it's in effect. It's in effect now, and this is the one that is, I think, has the most misunderstanding among the public, I think among lawyers, and to an extent among judges, about what it does. This is the somewhat notorious 50% time sharing presumption. The number of folks that have come before me since this went into effect that have just simply misunderstood what this means is amazing. There's I think a lot of misconceptions going on out there. And in fact, I had a guy in front of me just last week who tried to explain it to me. He wanted to explain to me what this meant, that basically it had to give him equal time sharing. And no, I don't really want you telling me what this new law does, because it does not require that a judge grant the parties equal time sharing. And I'll explain why. And this is important. If you take away anything from this talk that I'm giving today, take this away. The statute does not require equal time sharing. What it does is creates a rebuttable presumption that equal time sharing is in the best interest of the minor child. Now, that doesn't really do much. That doesn't really say much. To rebut the presumption, a party opposing equal time sharing must prove by preponderance of the evidence that equal time sharing is not in the best interest of the minor child. Now, the reason this isn't a big deal is because of this. Whenever a judge makes a decision about time sharing, whether deciding it should be equal, should be alternate weekends, should be something different, should be supervised, or should be, whatever rules, whatever provisions a judge wants to put into effect for time sharing, the judge is deciding by preponderance of the evidence that the time sharing plan that he or she's putting into effect is in the child's best interest. Because that's what we do. We got to figure out what's best for this child. This is a thing that, when I started doing this, really does take a shift in emphasis, a shift in how you're looking at things, because when you're working for a client, when you're lawyering, when you're working for a client, you kind of look at it as to, what does the client want? What does the client think is best? When you're the judge, you have to think about what's best for the child. There are plenty of circumstances where, a parent is deficient in a lot of ways, but it's still best for the child that this parent have majority time sharing, for whatever reason. We all know what goes into, making a case as to what's in the child's best interest, but actually I see people who focus a lot more on, why dad is a bum and, why mother is worthless, than explaining what's best for the child. I've done trials, these are mainly pro se folks, who don't even mention the child. All they mention is, what a creep the father is, or how negligent the mother is. And, I try to put the focus back on what's best for the child, as opposed to how bad the other parent is. So in any event, what the judge is always deciding is what's best for this child. And the judge is deciding that by a preponderance of the evidence. Preponderance of the evidence, and we've used that phrase a few times in a few different circumstances. Preponderance of the evidence is 50% plus one. I've had close cases where, is it better for the child to have this time sharing as opposed to that? And maybe close, but if you come down, it's a little better to do this than to do that, then that's a decision that's made by a preponderance of the evidence. And it's always done that way. It's always been that way. So in the past, there were no presumptions in the statute. All the judge was supposed to do is figure out what's best for the child and make a time sharing decision based on that, based on what's best. Now, what this has done is to create a presumption that you should start with equal time sharing. But to rebut it, you just have to show by preponderance of the evidence that equal is not what's in the best interest, meaning something else, some other form of time sharing is what's best for the child. But that's exactly what judges have always done. If you decide alternate weekends is what's best, judges decided by a preponderance of the evidence that equal time sharing is not in the best interest of the minor child. So all this really is doing is changing a burden of proof. In the past, neither parent had the burden of proving that equal time sharing was not in the best interest. Now, the party that does not want equal time sharing has the burden of proof, but you only got the burden of proof by proving by a preponderance of the evidence. And parties, lawyers have done that forever. So it's just not that big of a deal. It's wrong for parties to think that they can just walk in and get equal time sharing if they agree, or if neither parent can show that it's better for the child to live with them the majority of time. Maybe this will make a difference because they've not met the burden of proof to show that it's not in the child's best interest. But I want you to come away from this understanding that this is, well, it's significant. It doesn't end the discussion. That alternate weekends still may well be appropriate, and may well be appropriate in many cases when, I don't know, parties can't get along and they're going to continue to fight, and they live far apart and it takes, an hour in traffic to get the child to school, if you're doing equal time sharing. There's all sorts of reasons why it's not in the child's best interest to not have equal time sharing, even for good parents. So, if your client does not want to agree to equal time sharing, don't throw in the towel. This statute isn't going to make that much difference. All it shows is that you've got to show it. You've got to prove it. Okay, also part of this change is the most important, what I think is an even more important part, what I list at the bottom here. To modify a parenting plan, you no longer have to show that the change in circumstance is unanticipated. To get a modification of a parenting plan, you've got to show that there's been a change in circumstances that's substantial, in the past, substantial, unanticipated, and it's in the child's best interest to make a change. Now, as a result of that standard, the courts have always said that's a high standard, difficult burden to meet. As a result of that, the appellate courts over the last few years have become very, very hard to get along with regarding modifications. They had said things like, for example, moving is not a change in circumstance. So, moving, if you were 5 minutes away and now you're, an hour away in traffic, that move is not a substantial change. The child just getting older, a plan that was put in place when the child was 3, and now the child is 16. I mean, to me, there is nothing, that's clearly a circumstance, so there should be a modification. That's not the same child as they were when they were 3, but because it's certainly not unanticipated that the child is going to grow up, you couldn't make a change just because the child had gotten older. This statute eliminates that requirement of an unanticipated change in circumstance as a basis that something that has to be proven to make a change. So now, to modify a parenting plan, all you got to show is that there's been a substantial change in circumstances and that it's in the child's best interest to make the change. So I had a number of folks who came in, filed after the 1st of July and said, okay, there's been a change. Now the child's older, and a rebuttable presumption that now we should have equal time sharing. Well, it doesn't really quite work that way, that you still have to show that it's best for the child to make that change. And when you've got a circumstance where a child has, gotten used to a particular set of time sharing, the mere fact that a parent might want to have more time sharing, might think that it's best to make this change, if only because it'll reduce their child support. The removal of the unanticipated change in circumstances requirement is important, but it, again, is not really quite as earth-shaking as a lot would have us believe. Also in this statute, if there was a long-distance parenting plan in place, parents living more than 50 miles apart, when it was established that moving closer together is now considered a change in circumstances. This is another thing that the appellate courts had said, because moving is not a change in circumstance. If you were living, if you were living in Idaho and then you moved to Fort Lauderdale, just down the street, seems to me that that's a change in circumstance. But now the appellate courts had said no, moving isn't a change, and therefore you couldn't make a change. You couldn't change, get a modification of that ground. The statute now says you can. All right. The third significant change this year has been in paternity law. And this one is really more of interest to judges and lawyers, sort of in the nuts and bolts of how paternity law works. You may not have a lot of contact with this kind of statute, but it is when it happens, when it matters, it really matters. The law has been forever that the parents of a child are the child's natural guardians. They're the ones that got the control over a child. Parents are the natural guardians, and that the mother of a child born out of wedlock, the mother is the natural guardian of the child. Now, those two things taken together mean what? Well, how does a man establish himself as the parent of a child born out of wedlock? Statute says that by signing a birth certificate or signing the acknowledgement of paternity as provided by the Bureau of Vital Statistics, that when that document is signed and filed, the father becomes the legal father of that child. Biological fatherhood is something different, and that could be a whole nother topic, but to become a legal father, father signs the birth certificate or the acknowledgement of paternity form. So under the statute that says that the parents are the natural guardian of the child, everybody, myself included, always understood that when the father signed that birth certificate and got on the birth certificate as the father, he was now a parent under section 742.011. But the appellate courts a couple of years ago began interpreting it differently. They acknowledged that the statute said parents are the natural guardians, but then the next section, the next part says, and the mother is the natural guardian of a child born out of wedlock. So rather than saying, well, once the father signs a birth certificate, the father also becomes a parent, well, of course, saying, well, no, irrespective of whether their father is established as a legal father, statute says the mother of a child born out of wedlock is the natural guardian. So the father was kind of out of luck until he went to court and got an adjudication and a parenting plan, essentially creating a second-class form of fatherhood, which is contrary to pretty much everything most folks had really ever thought about how these two statutes, these two sections of the statute work together. And this can cause some real mischief. Say you've got a case where man and woman are living together, have a few children, they're not married, father's on the birth certificate, and the mother goes away, just moves out, moves away from the family. Father continues on, he can put the kids in school, can doctors, all this stuff because he's the father on the birth certificate. And the mother just goes away. And then 2-3 years later, the mother comes back and says, I want to take the children. Now, ordinarily, father runs to court, and let's say there'd been no order of any sort up to this point. Ordinarily, father runs to court, says, mother's been gone, it's not best for these kids to go. Ordinarily, and I've done this myself, I'd said, no, okay, we got to do best interest determination. Mom just can't come back and take the kids. But under these cases where the courts had said, statute says mother is the natural guardian of children born out of wedlock, they are basically saying, yes, she can. Even though father's been raising the kids, mother is the natural guardian for children born out of wedlock. So if she shows up, she gets the kids until such time as a court can determine what's best for them. And I think everybody pretty much acknowledged, even though I think about 3 district courts made decisions like that. This statute, Session Law 23-209, again, effective July 1st, makes both the mother and father, once the father has established paternity by signing the birth certificate, makes them both co-natural guardians of the child, essentially getting rid of this second-class fatherhood, and returns the circumstances to the way most folks understood it before the district courts of appeal kind of started messing it up. So it's important the first step, whenever a client comes in to see you or your attorney to when you're talking about children born out of wedlock, the first step has got to be to make sure that the father is named on the birth certificate. And if the father is named on the birth certificate, then he does have equal rights with the mother. And this statute, effective July 1st, makes it clear that that's the circumstance. All right. There's a new statute. It's known as Grayson's Law. This is Session Law 23-112, again, effective July 1st, that reformed some things in the domestic violence provisions. Florida is very concerned with domestic violence and its effect on children. I think we all naturally can know domestic violence is not good for kids, but the current research on child development really points out how bad, how harmful domestic violence is to children, especially young children. Children, ages birth to about 3. Any of you who have children, the changes that a child goes through from birth to age 3. This change tends to slow down, certainly still exists, but slows down a little bit after 3. That's because a child's brain is developing at a spectacular rate during those times. And stresses, adverse childhood experiences occurring, especially during those times, can have a real impact, a real negative impact on brain development and the long-term development of a child. And so statute has for a long time required courts to take into consideration incidents of domestic violence in making time sharing and other parenting determinations. If a parent has been adjudicated guilty of a domestic violence incident, there's a presumption against shared parental responsibility for that parent. Doesn't really tell you real well how to actually apply that. It kind of matters to me, for example, if that incident was 10 years ago with a different partner as opposed to last week. But the Session Law 2312 expanded the definition of domestic violence and what the courts need to consider in deciding what constitutes domestic violence. It's called Grayson's Law. It's a child that victim of a murder-suicide a couple years ago, I think in Broward County. And as I recall, I think that the mother had been denied a restraining order. And so what this statute does is that it expands the definition of domestic violence to include if there's been behavior that is abusive or threatening, intimidating, or controlling. Essentially making it, those are the bullying that does not involve actual physical violence. If a parent has reasonable cause to believe that they're in danger of imminently becoming a victim of domestic violence, and that domestic violence could be abusive, threatening, intimidating, or controlling behavior, no matter for how short a time, that can constitute domestic violence. It constitutes domestic violence for the purposes of entering a domestic violence restraining order, and it also constitutes domestic violence for the court to consider as one of the factors, the A through S factors in 6113 in deciding parenting. So when you get the close cases of domestic violence, we have intimidating, controlling, or actually I probably included, should have actually spelled controlling correctly there. But if you have intimidating or controlling behavior that does not verge into actual physical abuse, that can be considered domestic violence for purposes of either a restraining order or a determining parenting. Let me encourage you all to educate yourselves regarding the impacts of domestic violence. You frequently hear, well, the child wasn't there, didn't see it, didn't experience it. Child's an infant, couldn't comprehend or apprehend with the import of the incident. It was only a short incident, that sort of thing. Or an incident, the seriousness, the severity of the particular kinds of incidents. Domestic violence, for example, by strangulation is a more serious crime than other forms of domestic violence. And it's because the law does take into account the lethality of the actions, because the lethality of actions and putting hands around the neck is a particularly lethal kind of violence. And the law takes that more seriously. And when you are helping to assess a case, either for a domestic violence restraining order or as a victim, representing a victim of a domestic violence, assessing that lethality is an important thing to do. It's always so frustrating when you have a victim who is repeatedly victimized, both either by the same person or by serial victimizers. I tell you, I can't. It just drives me nuts. When just last week did a trial with a woman who was seriously abused by 2 consecutive live-in boyfriends, and the DCF had removed the children from her and put the kids back with those abusive fathers, not her. I said, oh my goodness, it's confounding to all of us to try to figure out what to do with these folks and to try to get them to understand. I mean, you might get them in court to say, do you understand how harmful this is to your child? Do you understand how harmful it is to you, and how bad it is for your kids to be exposed to this? And yeah, I understand. I tell you, okay, will never happen again. And then it does. Oh my goodness, it's just so frustrating to those of us trying to make decisions as to what to do in the cases. But I encourage you to educate yourself on these things. There's a lot of resources out there, a lot of seminars that I hope could become available to you to expand. And I'll tell you, it was eye-opening for me to learn about the physical effects of child development, physical effects of the development of the child's brain as a result of being exposed, of an infant's brain, to be exposed to domestic violence. So there's plenty for all of us to learn. I really appreciate your time. I'm going to try to make this PowerPoint available so that those of you who are participating can look it over again in your free time. Please avoid the typos. I'll blame it on someone else, but in any event, thank you all. I appreciate your time, and thank you for the work you do.